Hi, everybody. This is Camille from My HR Toolkit. I just welcome you to the webinar today. Thanks for coming on. For those of you who are new to us, My HR Toolkit provides HR software for SMEs, and we are running an ongoing program of webinars covering a variety of HR and business topics. Today, we're going to take a look at how to manage employee misconduct in a small business. And as a brief overview, we'll be covering the common types of misconduct that employers might encounter, when to deal with misconduct in informal or formal ways, and the basic formal procedure employers should follow. So following the presentation, which will be about 25 to 30 minutes, we'll also have time to answer your questions in a Q&A. And so if you have a look at your menu on Zoom, you should see a Q&A option. And that's the best place to add your questions for our guest speaker throughout the presentation and the Q&A. And there's also the Zoom chat, so do get involved in the chat with any observations, but please do ask questions in the Q&A so we don't miss them. And just as a general note, today's session is offering general and not legal advice. And before I continue on to today's webinar, we have got a webinar coming up in November. It's a little while away now, but quite relevant really for anyone interested in today's topic. Basically, we've invited another employment solicitor, Toby Pockron, on to talk about managing long-term absence, and in particular, how would you manage an employee with long COVID? So sort of managing things well, avoiding any sort of discrimination issues, etc. So I'm just going to pop a registration link to that in the chat. So if anyone's interested in joining us on next webinar, that's the place to go. Right, without any further ado, this morning here to talk to us about how to manage employee misconduct is Catherine Wilson. A little bit of info on Catherine. She's an expert employment lawyer and HR problem solver. She works as an employment partner at W Legal Limited and also runs her own employment law and HR consultancy, training and writing business, McBrowney Limited. So Catherine, very, very welcome. Glad to have you here today.
Hello. Yeah, really lovely to be with you all this morning.
Brilliant, thank you. Cool. I'll stop my screen share and I'll leave it to you.
Thanks, Camille. That's great. Well, good morning, everybody. Lovely to be with you today and to do this session on managing employee misconduct in a small business. I think 99% of the time, employers face no issues with their employees. Or put it another way, it's about 5% of the staff who seem to cause about 99% of the problems. I can say, though, that from my experience, that many of particularly my smaller business owners and employers feel that about 100% of their time is being absorbed on so-called employee issues, of which the most problematic, and the reason we're doing the webinar today, is definitely this whole question of misconduct. So focus today is, what do we consider we mean by misconduct in employment terms? How do we deal with it effectively? And what are the potential consequences of mishandling incidents of misconduct? I should say as well at the beginning that really this is the blackest point. Most misconduct never goes anywhere outside of the workforce and never ever goes to tribunal. But I think it's important that we understand from the beginning the absolute worst case scenario. So the starting point is, under employment legislation, there are a number of potentially fair reasons for dismissal, of which misconduct is probably the most self-explanatory. But even misconduct can on occasion cross over with other potentially fair reasons. And I talk later on about what some of those crossover points are. The other key thing is that to fairly dismiss, so if we're looking right at the end of the process, it's very important to understand that it's not just about having a fair reason. It's absolutely critical that you can demonstrate to the tribunal satisfaction that the decision to dismiss, even if they themselves would not have agreed with it, fell within the band of what we call reasonable responses. And again, this is particularly important, I think, because we're looking from a small business perspective, because reasonableness in this context is defined by nature and size. So the fact you're a small business is relevant. And I'm going to talk about some of the examples where that would give you a bit more latitude than it would say if you were a much larger concern. Couldn't stress enough, though, that reason is key, but process is even more important in this context. So I said at the beginning that misconduct, you would imagine, will be fairly obvious. So unacceptable, inappropriate, improper behaviour. violence, theft being two very clear examples, easy to identify. However, there are a number of other areas which are a bit more tricky. So, for example, poor performance or capability, as we call it in legal terms, can be a fair reason for dismissal. However, I want to draw your attention to the distinction between the can't do and the won't do. If we're looking at a can't do scenario, then clearly that could be seen as more of a performance issue. Performance improvement plans, training, warnings, etc. And dare I say it, another My HR Network webinar. If, however, it's a won't do, so failure to comply with reasonable instructions, or just, dare I say it, pure bloody mindedness, then clearly that could be seen as a misconduct. And it's for that reason that often, particularly with smaller businesses, and I'm going to talk about the importance of having a policy in a moment, but I do notice that for a number of smaller businesses, performance and conduct are all wrapped up together, which is clearly quite a challenge. Similarly, we can consider the difference between genuine long-term sickness absence, which is the type of thing that Toby's going to talk about in November, and what I call the Monday-Friday phenomena of persistent but very limited absenteeism. And again, it's that Monday-Friday regime which could be seen more as conduct than a genuine medical problem. Finally, the third type of potentially relevant crossover is what we call some of the substantial reasons. So, personality clash, breakdown in relationships, and again, that could also fall within this conduct heading. So, I think it's really critical that you identify or try to identify the correct reason. Why is that important? Well, primarily because if you don't correctly identify the nature of the beast, as it were, or the reason, then it's extremely difficult to carry out any type of fair process. You've got your hands tied behind your back at the start. Also, though, if you do get it wrong, don't worry too much, because tribunals do accept that employers do sometimes incorrectly identify the reason. But do your best, because it will make the whole process much easier for you. So what else do you need to be aware of really when we're investigating misconduct? Well, clearly the internal disciplinary policy and procedure is absolutely critical. If I have a policy, where is it found? How can I access it? I'd also add a third question to that is, when did I last look at it? Because I do see a lot of clients with policies that are looking very, very ancient. In cheese terms, they will be definitely out in the bin by now. So important to realise what policy you have. I also appreciate that many of you on this call may not have a policy at all, or only something very brief. Either way, it's very important as part of any investigatory process or drafting of a policy that you refer to what we call the ACAS Code of Practice on Disciplinary and Grievance Procedures. This sets out the main principles for handling disciplinary situations, and it applies to anyone legally classified currently as an employee. We'll talk a little bit about classification in a moment, but for these purposes, assume that that policy will apply to the vast majority of your workforce. It's also important, though, because as a matter of law, the policy you follow, and particularly this reference to the ACAS code, will be taken into account if the case ever reaches an employment tribunal. Now, arguably, different procedures can apply if an individual is classified as a worker. And again, perhaps another action point to take away is working out the correct classification of the individual you're dealing with. But my expectation would be that the vast majority of them would be employees. So if you haven't got a policy, you need to try and get one. There are plenty available online. It doesn't have to be something very complex. Starting point is look at the ACAS code. So we've sorted out our policy situation and we understand what's going on. How do I manage that misconduct? Well, the first stage is to evaluate what's happened. And minor so-called misconduct, such as repeated poor punctuality, can be dealt with informally and I would say on the spot. I think this whole evaluation stage is often overlooked. I think we underestimate the number of occasions where a quiet word, so-called, at the outset of a problem may be highly effective. Repeated trivial incidents over a comparatively short period of time, however, could justify a switch over into a formal disciplinary procedure. But the focus here is going to be on how to handle what I would call the more significant incidents of misconduct of the type described above. So we're talking about dishonesty and violence. And again, once we've evaluated what's happened, our starting point is investigation. I think there is an urban myth that there are some acts of gross misconduct which are so serious that no investigation is required and individuals can be dismissed on the spot. That, I think, is still technically legally true, but the number of those examples is extremely rare, and I would strongly counsel you against them. So we're going to work on the basis that an investigation is appropriate for almost 99.9% of potential misconduct disputes. Now, larger organisations operate with separate investigating managers as distinct from decision makers, but I appreciate that this cannot and is often not practical for smaller organisations. And when we go back to this whole question of whether or not the employer has behaved reasonably, then in that context, the fact that the same person investigates and decides the matter doesn't per se make the dismissal unfair and or any other final or written warning. However, I think there has to be some active consideration given as to the risks of one person playing that joint role. I think we sometimes call it judge and jury. We can discuss this perhaps in some of the questions, but for example, if the senior manager was also witness to the serious misconduct and you could be looking at a potential dismissal or final written, then I think active consideration should be given to using a separate senior manager and or even an independent HR consultant or some other independent, I think could be used business coaches, etc., if no internal resource is available. And if the decision is taken not to go down that route, it needs to be noted and there needs to be an explanation of why it was considered to be inappropriate. So, key elements of the investigation. If we're looking at gross misconduct, the next key decision is, are we going to look at suspension? Hopefully, if we have our policy will set out the grounds and the basis for suspension. But the key thing is, suspension is paid and it's not a disciplinary sanction. If we're looking at a potential gross misconduct, so a dismissal, so serious allegations, the theory behind that is that the employer could not afford a repetition of a similar level of misconduct. And it's quite difficult to show that if you're quite happy for the individual to continue in employment pending the actual disciplinary process. I appreciate the inconvenience facing smaller employers by taking out a key member of staff in this, but in terms of the legal process, it is fairly critical. Suspension, as I've said, is not a disciplinary sanction, and therefore it does not necessitate any prejudging or the fact that there may be a disciplinary process. Individuals do frequently come back from periods of suspension. Any suspension needs to be confirmed in writing and ideally independently witnessed. However, the formal rules about representation, which I'm going to talk about in a moment, do not necessarily apply. So, we've dealt with this whole issue of suspension. What's our next step? Well, I think the next thing to look at is the content of the investigation. And normally any investigation is reliant on evidence, generally from witnesses. These should ideally be agreed with witnesses and signed and dated. There's a particular issue with anonymous witnesses, which can be a particular problem facing small workforces, and I'm going to deal with this at the end. But you also need to consider what other external evidence you need. Could be, for example, a report on IT usage. When you have the evidence, you can consolidate the information into a written report. Now, I often get asked, is there any obligation to provide this report to the employee? And the key point about that is there is no strict legal obligation. However, the employee is entitled to know the detail of the allegations he or she faces. So if we give them the report, that does provide that obligation rather than having to replicate it or summarise it in a separate document. Bearing in mind that if the case does go nuclear and it does proceed to tribunal, then the report will be discoverable in any event. So it needs to be created, written with an eye on that wider audience. At the end of the investigation, there are two options. The first option is no further action required. I said at the beginning, this is not a runaway train. Investigation does not necessarily need or require disciplinary action. Alternatively, the investigation suggests that there is a disciplinary case to answer. Therefore, there needs to be a written invitation to a disciplinary hearing. It doesn't have to be a letter, could be an email, but there needs to be some formal paper trail. So housekeeping, date, time, venue, right to be accompanied, details of the allegation and or a copy of the report, plus a warning that depending on the outcome of that disciplinary, then at that point there could be a warning or a dismissal. Now, because we say that there is a potential to dismissal, that does not imply that we have in fact made up our mind that that will be one of the outcomes. Final point, which is often overlooked, is we need to get the employee to confirm their attendance, and if they are bringing an accompanying colleague and or trade union representative, then they need to tell us who that person is. We don't want anybody turning up with their godparent who happens to be a lawyer, and that happens again more frequently than you might think. So we've written to our individual and we've invited them to attend. How do we hold an effective disciplinary hearing? Well, I think a good start would possibly be making people watch this webinar, dare I suggest, but clearly the aim and training and pre-thought is hugely helpful. But the primary aim is to fact find and to test the aspects of the investigation. Provides an opportunity primarily for the employee to explain and amplify their response to aspects of the investigation, put forward mitigation, and anything else they want you to potentially consider. So whether or not it was the surrounding circumstances that led them to take this action, which was completely out of character, whether or not they want you to consider their 20 years outstanding service with no disciplinary warnings, whatever it is their opportunity. We'll say to clients, let's look at it as an 80-20. We want to spend more time listening than we do talking. I think as well, as part of that effective disciplinary process, we need to look at that role of the accompanying witness. So what is the role? Well, the role is primarily, I would say, supportive and to ensure fairness, not to give evidence on behalf of the employee. And it can be quite tricky in practice to maintain this balance, particularly, dare I say, if it's represented by a trade union representative. And your role as the person chairing, the decision maker, is to try and keep the process on track and avoid red herrings. There is always the right to adjourn, to get advice, to have a break. Again, this is not a runaway train process. Unjustified failure to allow the employee to be accompanied by the representative of their choice is a separate employment claim, punishable with 2 weeks' pay. So it's very important to comply. Always give the last word to the employee and ask them to confirm that they're happy with that process. You always need to keep a formal note of the meeting. This does not have to be I've got a message about you struggling to hear, so hopefully nobody else is, but please do tell me if you are. Always last minute, needs to keep a formal note of the process. Has to be very much the pros and cons in terms of recording. And again, as you will find, as we're finding today, that recording process has become increasingly common. Hearings can be adjourned for further evidence and more inquiries to be made. Always possible to adjourn before giving the decision. Discussion about sanctions in a moment, but crucial that any decision is in writing. Again, particularly if we're looking at dismissal, it is it's another legal right to actually have the details of the reason for your dismissal, so we can deal with that. There are various sanctions that are available, and I will talk about those in a moment, but key in that letter of decision, you must advise of the right of appeal and the process, normally the time frame for the appeal and the grounds or reasons. And again, any appeal needs to be dealt with by way of a fresh pair of eyes. So may need to consider at that stage using an external HR advisor if the senior management team is just simply too small or it's impractical to get that independent viewpoint. Final key point to understand, let's try and take this form, see if that works better. Final key point is whether the appeal is a rehearing or a review. If it's a rehearing, then it cures early defects and can even render an unfair dismissal fair. So massive impact though on the way you conduct the appeal if you're looking at an unfair dismissal, or indeed this rehearing. So I talked a little bit then, hopefully the sound is getting a bit better, but please let me know if there's anything else I can do. I then wanted to talk a bit about sanctions. Assuming you can establish that the reason is misconduct, then there are a range of potential sanctions which are not automatically gross misconduct and not automatically dismissal. A single act of serious or gross misconduct can justify summary dismissal for a first offence with no payment of notice monies. But you need to be satisfied in the balance of probabilities that not on the so-called criminal standard of beyond reasonable doubt. Dismissal takes effect only when the employee is notified of dismissal, which can be the day after or even a couple of days afterwards if the employee is not physically present and given an oral decision. Alternatively though, and I want to stress this, formal and due inquiry, alternative punishments may also be appropriate. First or final written warnings remain on record for a specified period, normally 6 to 12 months, but depends on what your policy says. Repeated misconduct during the currency of the earlier warning can entail a further warning or a potentially even dismissal. And this is what we call a sort of cumulative misconduct. Key points though, if we're looking at a cumulative, so somebody's working their way through effectively verbal, first, final and exit, is that a cumulative dismissal, unlike a summary dismissal, is on notice and or a payment in lieu of notice. Also, the process at all stages is crucial if the dismissal is fair. So if there's a irregularity, let's say at the written warning stage, that will taint a dismissal at the final stage. Classic mistake is didn't allow somebody to be accompanied and or didn't give them adequate information about the allegations. So that's my sort of whistle stop of some of the key areas. So that presumably is giving you some food for thought. I also wanted just to flag up some final points really of tricky situations. First tricky situation is my employee has less than 2 years service and or is still in their probationary period. So do I have to go through all this faff? Can't I just move to dismiss? Well, since 2012, the qualifying period of service to bring an ET claim is 2 years, which starts from the beginning of the employment under the relevant contract of employment. However, I think it's always really important to appreciate that even though that is the baseline, there are a number of other cases where no qualifying period is necessary, such as linked to trade union duties, more commonly, particularly in the last 18 months since COVID, whistleblowing allegations, concerns about health and safety, and most commonly, the reason for dismissal being linked to discrimination. So the protected characteristic under the Equality Act, such as race or sex. So to simply think, right, I've got less than 2 years, I don't need to do anything, is quite a high risk strategy. As they say, people know their rights, and you can find yourself at the receiving end of some fairly unpleasant claims at that point. So what can you do to protect yourself? Well, the key point is to make it clear that a shorter process will apply either during the probationary period and or that there is some sort of minimum process which would apply during, let's say, the first couple of years. My only concern about having separate processes is sometimes we don't always get it right in terms of working out how long somebody has worked, particularly if there's been a period of previous service with the employer, possibly on an agency basis. So I think there are some risks of it. There should always be a minimum process, irrespective of how long anyone has actually worked in the business. Next tricky situation is my employee is off sick. Now, clearly, if the employee is off sick with some significant illness for some period of time, it would not be considered fair to force them to participate in a disciplinary process. However, in certain situations, and if the absence is going to cause massive delay, the process can be delayed. Medical evidence is crucial, nature of the sickness and fitness to participate. you must make sure that the individual, if you're going to go ahead while they're off sick, can actually participate. Tribunals are particularly unkeen, and one of the cases I dealt with quite recently, about disciplinary processes in hospital, for reasons which I think would be fairly self-evident. But it is not an automatic in each case on its own merits. Next thing I talked about a little bit earlier was this whole question about anonymous witnesses, particularly common in small workplaces. Attributed, signed evidence, witness statements by named individuals is obviously desirable. However, it can still be fair to rely on anonymous witness statements. Key point though is if you're the decision maker, you need to understand why the person wishes to be anonymous. In particular, consider whether or not this goes to the truth of what they're saying or the validity, and also whether there's any inappropriate motivation behind the statement itself and the quest for anonymity. So not an automatic knockout would be the answer. Next issue is actually my representative is not available, is not suitable. Key point, primary obligation is upon the employee to organise a colleague. However, if let's say they're suspended and the condition of suspension is that they don't contact anybody working in the organisation, clearly the employer has a role to play in facilitating. There's also some case law which suggests that an employer should not veto a choice unless in extreme circumstances. For example, proposed colleague is inappropriate due to prior involvement as a witness or confidentiality concerns. However, if you're asking the employee to change the representative, then you need to give them ample opportunity and facilitate that. Equally, employee can ask for the hearing to be rearranged, normally because of the non-availability of their union representative. Employee should suggest a date and a time that's reasonable, and reasonableness in this context is when everybody else is involved is usually at work and available, and also within 5 working days of when the meeting was originally due to take place. It'd be fair to say that over the last 18 months, those rules have been significantly stretched, and we've been looking at significant delay simply in organising this type of delay and representation. Next point is my employee has a disability. How does that impact on the way in which I'm managing their misconduct? Well, assuming you're aware of the disability, then as employer, you have to make reasonable adjustments to accommodate that disability. These can include adjustments in terms of timing, location of hearing. More commonly though, it will be a reasonable adjustment for your employer to allow someone to accompany, such as a carer, family member, mental health advocate. And we might allow that accompanying person at a much earlier stage than we would in relation to an employee without a disability. So for example, in a probationary review and or a concern about a relatively minor area of misconduct. Finally, there are situations where, due to the nature of the allegation, the employer feels they have no option but to dismiss, but the evidence is inconclusive. And I talked about this right at the outset, namely what we call some other substantial reason. An example which pops up quite often is that if there is significant evidence of safeguarding concerns for vulnerable adults and or regulatory financial services breaches. And the final key point is that these so-called SOSRA, or some of the substantial reason dismissals, are on notice or payment in lieu. But of course, they may justify a dismissal in circumstances where a summary dismissal without notice was simply not justifiable. Finally, and I put this forward very much as a last resort, it's always possible to go down the protected conversation route, either pre or after a decision has been made, and to try and enter into a settlement agreement as an alternative to a dismissal. And again, perhaps another topic for my HR network, Camille. And then finally, I just wanted to give you a little case study because, as you might expect, most cases of misconduct are fairly clear-cut. So the number of cases that actually go to a tribunal are very rare and infrequent. But there was a case in 2020 called Bassett and the Education Partnership Trust. It's not a small employer, multi-academy trust created in 2012, several thousands of employees. procedures, as those of you involved in education might know, coming out of its ears. However, it's a relatively rare case where the tribunal considered the conduct of conduct-related investigation an outcome. The facts are irrelevant. It's probably well known as the child in the cupboard case, but suffice to say, the teacher ended up being dismissed following a classroom incident with a pupil. And there was a strong implication, actually, that the pupils had lied. But for our purposes, I want to consider on the 19 areas where the tribunal identified significant mistakes. The first was over-reliance on the statements of pupils, brackets, as opposed to staff, and with no consideration being given to the lack of corroboration and no possibility that the pupils were lying. A rather subjective view by the employer of the teacher's management style needs to be more objective. Look at getting some expert advice. Failure to give sufficient weight to teachers' previous experience and exemplary record. Very, very important. This is not to say that people who have worked for 25 years, as one of my clients says, well, they've not been caught. That is an attitude to it. But the fact is, if somebody has a clean record, that does need to be taken into account. Conduct of the appeal on written submissions without even seeing the teacher remotely. Very important in these post-COVID times when we're all using Zoom and Teams. Important because the panel drew an adverse impression that the teacher had showed a lack of remorse, whereas in fact, they profusely apologised for what had gone on in the classroom. And then a final point to those of you with a HR bench on the call, they were very unhappy with the role of the HR advisor. They felt that they had overstepped the mark from being an advisor to, in fact, becoming an influential decision maker. So definitely a sort of warning, as it were, about how to conduct the hearing itself. So those are my preliminary thoughts. Hopefully that's given you plenty of food for thought, and I apologise if the sound wasn't good in all parts. But the focus of the session is really to answer any questions. So I'm going to now hand back over to Camille, and we can have a look and see what's in the Q&A and chat box.
Okay, fantastic. Thank you very much for that, Catherine. It was a great overview of a lot of the issues, particularly in what can be quite a complex area. So yeah, really thank you for that. And we do have a few questions coming in already. I was kind of expecting we get some questions in because there's lots of different aspects to this. So I'll sort of launch into those, Catherine. So got a few. We've got one that's coming from Thomas quite early on, and who asked, prior to the disciplinary meeting, are you obligated to provide the employee and representative with details of the investigation, so sort of any investigatory stuff for the misconduct?
I think there is an obligation prior to the actual disciplinary hearing to explain to the employee, and by extension his representative, exactly what you're going to be talking about. That doesn't necessarily mean the report. We often find people try and get hold of the report if it's not forthcoming through some data subject access requests, but that's a totally different kettle of fish. But the key point is they need to have, yes, they need to understand what they are facing, because how can they prepare? And that goes to fundamental fairness. So often easier to give the report, but certainly can be dealt with just with a detailed letter of invitation to the disciplinary, setting out what the allegations are.
Brilliant, thank you. So hopefully Thomas has answered your question. If you have any others, do chime in. We do have a question from Patricia, who was asked, if an investigation is complete and it's found that the complaint is substantiated, but the company is aware of mitigating circumstances, could this be dealt with by issuing a written warning without having to hold a disciplinary hearing?
I mean, it could be dealt with in that way. The problem is, if there's another act of misconduct, the fact that we didn't have a formal disciplinary hearing in itself would mean that that written warning was technically unfair. So we couldn't rely upon it. If we know about mitigating circumstances, I think it's always better to have a disciplinary hearing, even if that hearing is quite brief. Because I think if we simply do it by a written warning, and we then need to rely on the warning or something else goes wrong, which it might, then we can't rely upon it. So that's the main process, because as I said, if we're looking at these cumulative series of warnings, each part of the process has to be correct.
Thank you very much. We do have a question in from an anonymous person. I think this is more performance related than misconduct related, but sort of relevant to some of the things you were talking about. They've said really useful information. Thank you. My question is, if we hire a temporary staff for the Christmas period, where do we stand if we don't believe they're doing the job well enough and want to replace them? And they've said they have a company size of 20 people with an additional 12 people over Christmas. So I suppose it's kind of a performance issue or potentially a misconduct issue, depending on the circumstances, really.
I mean, I think you can still, if you don't believe they're doing the job well enough, you can still replace them. I think you just need to give them, what I would say is they need to have a warning that they're not doing the job right. I have noticed clients where they have just simply brought people in and sacked them within a couple of days and with no warning at all. Now, I can see the practical benefit of that, but some of those, sometimes that can be problematic if those individuals do, notwithstanding the fact that they're very short servers, have, let's say, a protected characteristic. So as long as you've got a process, that's why I'm very keen on shorter disciplinary processes, let's say during the probationary period, and or when you recruit these people, you give them a period of trial, you give them some feedback, and if it doesn't work out, then they go. Then you've protected yourself from those very rare examples where you can fall foul of the shorter time periods.
And I suppose, I mean, I guess it is just kind of partly time would be pressing in that example, but I think that obviously if someone is showing that they're following the procedure, even if it's a bit more compact, would that sort of show well in a tribunal?
It would. It can be, one, it's a very rare occurrence, but also it can be a very compact procedure.
Yeah.
And I have noticed clients who've managed to do it within about 48 hours. So it's about how you manage and induct those people, and if it's clearly not working out, and all the other differences if people just simply fail to turn up. But ignoring that for the moment, I think you can need a process, but that process can be very short.
Okay, brilliant. And we've got a question in from Jack, who has asked, I think this was based on the case with the teacher you were discussing earlier. Jack has asked, how can you, as a HR advisor or professional, make sure you don't cross that line from advisory into deciding influence?
That is not straightforward. It's actually, in a way, it's, you see it, there has to be some credibility. The person who's making the decision has to look credible, as if they would actually have made the decision rather than being pushed into it by the advisor. So how do we make them look credible? Well, one of the things we can do is to make sure that they have that training and that confidence, because effectively that is the key part. Now, I talked a bit about recording. One of the problems with recording is if you have a very competent HR advisor, the full extent of their involvement, shall we say, is a lot more obvious on a recording than it is in a written note, which is not a shorthand minute, but is a a summary of what's gone on. So that's one of the disadvantages of recording. I think the key thing is you just have to make sure that you try not to cross that line. It happens. I think most people would appreciate that the HR advisor has got a lot more experience than the manager, so you would expect them to play an active role. Other clients have a view, which is basically that the decision maker retires without the HR advisor to make the actual decision. That seems a little bit OTT to me, but I can see where they're coming from, because certainly from the perception of the representative and the employee, it does make it look more like they have made the decision rather than, as often is the case, they leave and the HR advisor is left with their manager. So I think a lot of it is about presentation rather than substance.
All right, brilliant. Thank you, Catherine. We have like a couple more questions coming in, and everyone do feel free to ask if you do have a question. This is one from me, actually. I was just thinking about, you said quite early on about having a robust policy for these matters and for employees, but then how you need to kind of be on the lookout for sort of employee-worker distinctions. And I was just sort of wondering, how that may affect misconduct, on how to handle misconduct if someone's a worker instead of an employee, and maybe what some of the potential pitfalls could be to look out for.
I think that sometimes people feel because an individual is so-called worker that they don't have the same rights as an employee. And one, we know that the whole law to do with workers is incredibly complicated, and two, one often sees a lot of workers, so-called, who really are employees.
Yeah.
So they could have brought the claim, and because they've been treated as workers, they've had not even the most minimum or rudimentary process. So for some clients, they just include everybody, or they have one policy for short servers and one policy for everybody else. I think it's probably easier for a smaller business to have a simplified policy that applies to everybody, and you're not making those distinctions and choices.
Yeah, it's just safer, isn't it?
It's just safer, and it's quite difficult because with the best will in the world, you probably don't want to be making those decisions when you're not sure, and also when you're in the heightened tension, if you like, of dealing with an issue of misconduct.
Yes, yeah, it makes a lot of sense. Cool. Got a question in. Somebody has asked, is there a mandatory minimum expiry time for having a disciplinary record based on misconduct, or is this just down to company policy?
It's generally down to company policy, but if you look at the ACAS code, it does recommend. So the norm is between 6 and 12 months for a written warning or a final warning. I have seen clients where they have gone for longer periods. You can go for a longer period, particularly though you would need to make it clear in the disciplinary policy that, let's say, a written warning stays on the records for, say, 6 months, but in exceptional times it can be a longer period. I think there is an issue, though, which is in the tribunal terms, what they talk about is the sword of Damocles waiting to drop. So let's say if you wanted to give somebody a final warning, as one of my clients did, which would last forever, then the tribunal felt that was grossly unfair because they felt that he could never recover this particular employee and that was oppressive. So if we go back to our reason plus process, we fell down on the process. But it is all about what the company policy says. I would always advise you to give yourself a little bit of wriggle room because there may be instances where it is so serious, particularly if we're looking at that final warning, you would want it to stay on the file for longer than certainly 6 months and possibly longer than a year. But I would say 2 years is probably absolute tops.
That's some good advice there. And just to add a little plug to our software, because there's something relevant here, we do have a document management system within my HR Toolkit where you can keep all those important HR documents, and particularly around disciplinary procedures. You can kind of have notes and documentation. You can also send out reminders for things as well, so you keep on top of it. Because I think in some circumstances it would be the case that there is a warning on the record and then it just kind of gets a bit looked over or forgotten about, but that would probably be weighing on the employee quite a bit more. So it's just those circumstances where it's good to have reminders and be able to kind of have that process. So just thought I'd add that little plug. But yeah, I'll move on to the next question. So another question from Jack, who asked, on the topic of shortened disciplining processes, is there a minimum amount of notice you have to give employees to invite them to a disciplinary or investigation meeting?
Yeah, the norm is probably 5 working days. I can see, though, if we go back to that earlier question, that would be, say, 10 or 15. If you've only got there for 12 weeks, that seems a bit excessive. You need a minimum, really, of 24 hours. I would say 48 hours would be the ideal. There is this right to be accompanied, but I think if we're looking at verbal, I stress this really, a lot of these issues should be dealt with under that informal process, which means you don't have to have the representation, you don't per se have to have the notice, you need to have that interaction with the individual. So, I think we're looking at 24, 48 hours. Certainly, I think if you're looking at terminating someone's contract, I would be erring towards 48 hours rather than, on the spot, as it were.
Okay, brilliant. So that's all the questions we've had in so far. I can always waffle for a tiny bit just in case we've got any more coming in. I'm very good at that. But yeah, I just wanted to say thank you so much, Catherine, for all your sort of advice and expertise just generally on this topic. Like I said in the beginning, obviously seeking particular legal advice is always important in these situations, but also just having a general background knowledge of these matters and what to look out for could be really helpful. So yeah, I think not had any more questions in, so clearly everyone's had their questions answered. So yeah, I'll just quickly remind everyone that we do have another webinar coming up in November on managing long-term absence, and so looking at kind of the phenomenon that has been long COVID and how that's kind of affected things, but also managing long-term absence more generally and how to do that well. So I will just send a link to that again in the chat in case anybody wants to sign up for that one. And yeah, but in the meantime, Thanks everyone for your questions and for coming on today. And thanks so much to Catherine as well. It'd be really great to hear what you thought in the chat of our webinar, if you want to say anything you found particularly useful. And yeah, other than that, I think that's us done for today. Thanks very much, everybody.
Thank you.
Thanks, Catherine. Cheers, bye.
Bye-bye.